Welcome to the Immigrant's Way podcast with the immigration attorney Margaret W. Wong with over 40 years of experience. Enjoy.
Hey, today's topic is Special Juvenile Status. So what is a Special Juvenile Status? That means at least one of your parents had to have abandoned, neglected, and abused you. And also, you should not be in touch with them during the statutory period, depends on the state. So ward of court dependency action is a state action. So once the state action you won, now we go to federal immigration law, which is USCIS, and file the 360. Once the 360 is approved, now you have to wait for quota to file for green card. The nice thing about green card is that even though you enter illegally or legally or out of status or in status, you can still get the green card. It's very much like WAWA. WAWA is a situation where you're an abused man or abused woman, and you were seriously abused by your domestic married partner. It could be same sex or different sex. It could be American citizen or foreign person or foreign born green card holder. Then you can do WAWA is file same thing as a 360. Ward of court is also 360. That's what we call dependency action. All right. So as I said earlier, there are 4 types of visa petition. You have 360, which is WAWA, religious, ward of court. You have I-130, which is marriage case or grandparents case or a sister and brother case. You have I-140, which is employment-based, could be national interest waiver, a perm, or extraordinary capabilities, or it could be also 526, which is the EB-5. All right, those are 4 visa petition. So special immigrant is very much the 360 case. Always remember what forms, then you know how to do it. Most 360 absorbs illegal stay, and even WAWA absorbs perm bar. So for example, I was an abused man. I'm trying to be gender neutral here. So I'm an abused man. My wife lured me back to China, and then I came back illegally. That's what we call perm bar, because I stayed here illegally for more than 1 year. I left and I came back undocumented or illegally. That's a perm bar. But if that perm bar is a result of that abuse, 360 WAWA absorbs perm bar. But for a ward of court case, because most children has to be under 18, unless you live in Maryland or New York, you could be over 18, but has to be under 21. So the ward of court case or dependency case or whatever you call it under the state has to be filed under the state law. It has to have a special finding. Some judges are very tough. They don't want to give you a special finding because they don't want us to go to court and get all these stuff, because they believe in the separation of state jurisdiction versus immigration jurisdiction, which is federal. But other judges, they would feel sorry, but they have a big hearing. Versus years ago, when I personally still do these, and we still do it now, but my other lawyers do it now. But when I used to go to court for the kids, the judge would just go in chambers. In chambers means that we don't have an open court hearing. We sign the papers, we're done. So now they have a big court hearing. You really have to prove no contact with the abuse parent. Has to be really abused. You couldn't just say, my parents were abusing me and stuff like that. You can't do that. You have to have some sort of, it should be true, because I really don't want to hurt other kids who comes after you. And now they just say, wow, someone lied to me, I'm not going to believe you. All right. So once the special finding, final judgment entry from the state is approved, it has to be, the final judgment has to be under the age. The 360 have to be applied between 18 and 21. So it's no problem, because federal law, 21 is aging out, all right? The green card could even be filed after 21 or before 21 and could be approved after 21. That's okay. So remember the ages. That's why in immigration law, the ages are very interesting. Marriage had to happen between the parents before the kid is 18 for the step to be a step. Step is important because you could get green card under the step citizen parent, number 1. Number 2 is aging out is 21, is not 18. You have also yet to protect and give your parents your green card you have to be over 21. It cannot be over 18. All right. So step age has to be 18. To sponsor your own parents has to be 21. But if you get the green card through an adoption, you cannot sponsor your natural parent. All right. So these are special exceptions to the aging out rule. CSPA, Child Protection Act, that started in year 2000, 2002, Child Passport Act that started in year 2000. Those were the golden ages for children who came to America and could, because one of your parent, the adoptive divorced parent or the custodian divorced one, as long as they're American citizen, you became a citizen under the age of 18. That creates a lot of controversy because in certain countries, for example, your father never married your mother, but your mother has sole jurisdiction, but your father is a citizen, so they need to be legitimized and paternalize you before you were 18 to give you status. So a lot of them, you know how they don't pay child support, they don't ignore you, they don't legitimize you, then you're out. All right. So that's why laws like this should change, because America is becoming very gender. But that's probably the only thing about fathers that's a problem. Aside from that, it's okay. If the mother is a citizen, no problem, because you came from your mother. It doesn't matter if she ever married the father. You are the citizen. All right, that's very nice. So any more questions, call me, email us, follow us, and I would love to give you answers.